Freddie. The father of a teen accused of killing 4 people in a shooting at a Georgia high school remains behind bars today. Colin Gray is being held without bail. He was arrested and charged for allowing his son, Colt, access to the weapon used in the shooting earlier this month. The case has raised questions about what legal responsibility and potential consequences parents could face for cases involving their kids.
So joining us today is local criminal defense attorney Logan Campbell. Thanks for being here.
Of course, thank you all for having me.
So on that Appalachia high school case out of Georgia, we talked about the father being charged in it as well. Tell us, break down why the father was charged, on what grounds?
Yes, absolutely. So the dad is actually charged with more crimes than what his son was charged with. The dad is charged with 2 counts of a second-degree murder, 4 counts of involuntary manslaughter, and 8 counts of cruelty to children. The key reason why he was charged, it wasn't just because he provided a firearm to his son that was used in the commission of the crime, and he actually provided that firearm as a Christmas present. But the key part in the case is that the father provided this firearm just months before when his son was being investigated. The dad was contacted by police who were investigating potential threats that his son had made. So the legal theory being in this case is that in providing the firearm to his 14-year-old son, which by itself is not illegal, but in providing it to his 14-year-old son, he was doing so negligently or recklessly when he reasonably should have known that his son could have committed this crime.
So I know this case has opened up a lot of questions and conversations about cases involving a minor or a parent-child relationship. So talk to us about what responsibility could fall on parents in cases involving minors.
Right, so that responsibility, it goes back to a lot of what did the parent know, or what should the parent have reasonably known. Here in this Georgia case, the prosecution is going to make a lot of arguments and hammer home that the dad knew that his son was being investigated or had been investigated before for potential threats to the school, and therefore by providing this firearm to his son, he was placing other lives in danger. So it goes back to what the parent knew or what they should have known. But you can also ask, is this a situation where the parent maybe turned a blind eye, possibly not knowing that the son or his child was capable of committing a crime? Or were they assisting, were they actually encouraging the commission of the crime?
And so I guess a lot of that is red flags. If there were red flags that they should have been able to pick up on, then that is a big part of these types of cases.
That's correct.
When we're talking about people who own guns, parents who own guns, what kind of legal duty do they have to secure the gun in their home when they have a minor? Do they have one, a legal duty?
They absolutely do. Here in Texas, we have a very specific law, the Texas gun storage law, which broadly states that if you have a firearm in your residence and you have a minor child or a child being an individual under the age of 17, you are required by law to securely store that firearm. The intent behind the law being that you don't want a child to have access to a firearm without adult supervision. Under this law, there are exceptions, as I said earlier, adult supervision, and if this firearm is being used for lawful purposes such as hunting or other sporting events. But broadly speaking, if you have a readily dischargeable firearm in your residence, meaning loaded with ammunition, you must securely store that firearm to prevent access to that firearm from a child. If you do not, here in Texas, that is a Class C misdemeanor. And it's important to note that a Class C misdemeanor is the lowest level of punishment that we have in Texas. It's a fine-only offense with a max fine of $500. If you go a step further and you do not properly secure the firearm and a child does gain access to that firearm, discharges a firearm causing serious bodily injury or death to another individual, then the case will increase in punishment, not to a felony though, but to a Class A misdemeanor. Class A misdemeanor being punishable up to 1 year in jail.
I want to circle back to the Georgia case. It's of course still playing out, but if the case ends in a conviction, would it set some kind of precedent? What could it mean for future cases that may have similar components to them?
Right, so legally speaking, what happens on the Georgia case will not necessarily have a binding effect on the law here in Texas. You have 2 different states, 2 different state laws. However, what this Georgia case is signifying is kind of a shift in public opinion towards holding parents responsible for potentially allowing access to firearms if their child then takes that firearm and uses it in the commission of a crime. But what I was stating earlier, here in Texas, the only case that we have, or the charge that we have that's directly on point, where if a child gains access to an unsecured firearm, discharges it, causes serious bodily injury or death, here in Texas, it's currently just a Class A misdemeanor. It's not a felony like what the dad is being charged with in Georgia. So ultimately, it would be up to the Texas legislature to change the law to allow for a harsher punishment if they so choose.
And that's even if that results in a death of somebody, still a misdemeanor.
Yes, under the Texas Penal Code, it is a Class A misdemeanor.
Interesting. All right. Well, Logan Campbell, thank you so much again for your expertise on this topic. We appreciate having you.
Thank you all again.
Still to come.